2. Although the events we investigated involved discrete acts, e.g., the president's statement to Comey about the Flynn investigation, his termination of Comey, and his efforts to remove the special counsel, it is important to view the president's pattern of conduct as a whole. That pattern sheds light on the nature of the president's acts and the influences that can be drawn about his intent. And the inferences that can be drawn about his intent. Our investigation found multiple acts by the president that were capable of exerting undue influence over law enforcement investigations, including the Russian interference and obstruction investigations. The incidents were often carried out through one-on-one meetings in which the president sought to use his official power outside of usual channels. These actions ranged from efforts to remove the special counsel and to reverse the effect of the Attorney General's recusal to the attempted use of official power to limit the scope of the investigation to direct and indirect contacts with witnesses with the potential to influence their testimony. Viewing the acts collectively can help to illuminate their significance. For example, the president's direction to McGahn to have the special counsel removed was followed almost immediately by his direction to Lewandowski to tell the Attorney General to limit the scope of the Russia investigation to prospective election interference only, a temporal connection that suggests that both acts were taken with a related purpose with respect to the investigation. The president's efforts to influence the investigation were mostly unsuccessful, but that is largely because the persons who surrounded the president declined to carry out orders or accede to his requests. Comey did not end the investigation of Flynn, which ultimately resulted in Flynn's prosecution and conviction for lying to the FBI. McGahn did not tell the acting attorney general that the special counsel must be removed, but was instead prepared to resign over the president's order. Lewandowski and Dearborn did not deliver the president's message to Sessions that he recede from his recollections about events surrounding the president's that he should confine the Russia investigation to further election meddling only. And McGahn refused to recede from his recollections about events surrounding the president's direction to have the special counsel removed, despite the president's multiple demands that he do so. Consistent with that pattern, the evidence we obtained would not support potential obstruction charges against the president's aides and associates beyond those already filed. B. In considering the full scope of the conduct we investigated, the president's actions can be divided into two distinct phases reflecting a possible shift in the president's motives. In the first phase, before the president fired Comey, the president had been assured that the FBI had not opened an investigation of him personally. The president deemed it critically important to make public that he was not under investigation, and he included that information in his termination letter to Comey after other efforts to have that information disclosed were unsuccessful. Soon after he fired Comey, however, the president became aware that investigators were conducting an obstruction of justice inquiry into his own conduct. That awareness marked a significant change in the president's conduct and the start of a second phase of action. The president launched public attacks on the investigation and individuals involved in it who could possess evidence adverse to the president, while in private, the president engaged in a series of targeted efforts to control the investigation. For instance, the president attempted to remove the special counsel. He sought to have Attorney General Sessions unrecuse himself and limit the investigation. He sought to prevent public disclosure of information about the June 9, 2016 meeting between Russians and campaign officials, and he used public forums to attack potential witnesses who might offer adverse information and to praise witnesses who declined to participate with the government. Judgments about the nature of the president's motives during each phase would be informed by the totality of the evidence. 3. Legal defenses to the application of obstruction of justice statutes to the president. The president's personal counsel has written to this office to advance statutory and constitutional defenses to the potential application of the obstruction of justice statutes to the president's conduct. As a statutory matter, the president's counsel has argued that a core As a statutory matter, the president's counsel has argued that a core obstruction of justice statute, 18 U.S.C. and 1512 C.2, does not cover the president's actions. As a constitutional matter, the president's counsel argued that the president cannot obstruct justice by exercising his constitutional authority to close Department of Justice investigations or terminate the FBI director. Under that view, any statute that restricts the president's exercise of those powers would impermissibly intrude on the president's constitutional role. The president's counsel has conceded that the president may be subject to criminal laws that do not directly involve exercises of this Article II authority, such as laws prohibiting bribing witnesses or suborning perjury. But counsel has made a categorical argument that the president's exercise of his constitutional authority here to terminate an FBI director and to close investigations cannot constitutionally constitute obstruction of justice. In analyzing counsel's statutory arguments, we conclude that the president's proposed interpretation of Section 1512 C.2 is contrary to the litigating position of the Department of Justice and is not supported by principles of statutory construction. As for the constitutional arguments, we recognized that the Department of Justice and the courts have not definitively resolved these constitutional issues. We therefore analyzed the president's position through the framework of Supreme Court precedent addressing the separation of powers. Under that framework, we concluded Article II of the Constitution does not categorically and permanently immunize the president from potential liability for the conduct that we investigated. Rather, our analysis led to conclude that the obstruction of justice statutes can validly prohibit a president's corrupt efforts to use his official powers to curtail, end, or interfere with an investigation. A. Statutory defenses to the application of obstruction of justice provisions to the conduct under investigation. The obstruction of justice statute most readily applicable to our investigation is 18 U.S.C. 1512 C.2, Section 1512 C, provides whoever corruptly alters, destroys, mutilates, or conceals a record, document, or other object, or attempts to do so with the intent to impair the object's integrity or availability for use in an official proceeding, or 2, otherwise obstructs, influences, or impedes any official proceeding or attempts to do so, shall be fined under this title or imprisoned not more than 20 years, or both. The Department of Justice has taken the position that Section 1512C2 states a broad, independent, and unqualified prohibition of obstruction of justice. While defendants have argued that subsection C2 should be read to cover only acts that would impair the availability of integrity of evidence, because that is subsection C1's focus, strong arguments weigh against the proposed limitation. The text of section 1512C2 confirms that its sweep is not tethered to section 1512C1. Courts have so interpreted it. Its history does not counsel otherwise, and no principle of statutory construction dictates a contrary view. On its face, therefore, Section 1512C2 applies to all corrupt means of obstructing a proceeding pending or contemplated, including by improper exercises of official power. In addition, other statutory provisions that are potentially applicable to certain conduct we investigated broadly prohibit obstruction of proceedings that are pending before courts, grand juries, and Congress. See 18 U.S.C. 1503, 1505. Congress has also specifically prohibited witness tampering. See 1 U.S.C. 1512b. 1. The text of Section 1512 C2 prohibits a broad range of obstructive acts. Several textual features of Section 1512C2 support the conclusion that the provision broadly prohibits corrupt means of obstructing justice and is not limited by the more specific prohibitions of Section 1512C1, which focus on evidence impairment. First, the text of Section 1512C2 is unqualified. It reaches acts that obstruct, influence, or impede any official proceeding when committed corruptly. Nothing in Section 1512C2's text limits the provision to act that would impair the integrity or availability of evidence for use in an official proceeding. In contrast, Section 1512C1 explicitly includes the requirement that the defendant act with the intent to impair the object's integrity or availability for use in an official proceeding, a requirement that Congress also included in 2 other sections of 1512. See 18 U.S.C. 1512A 2B 2. Use of physical force with intent to cause a person to destroy an object, with intent to impair the integrity or availability of the object for use, is in an official proceeding. 1512B2B. Use of intimidation, threats, corrupt persuasion, or misleading conduct with intent to cause a person to destroy an object, with intent to impair the integrity or availability of the object for use in an official proceeding. But no comparable intent or conduct element focused on evidence impairment appears in Section 1512B2. C2. The intent element in Section 1512C2 comes from the word corruptly. See example United States versus McKibbins 656F3D 707 711, 7th Circuit 2011. The intent element is important because The word corruptly is what serves to separate criminal and innocent acts of obstruction. Internal quotation marks omitted. And the conduct element in section 1512C2 is obstructing, influencing, or impeding a proceeding. Congress is presumed to have acted intentionally in the disparate inclusion and exclusion of evidence-impairment language. See Loughran versus United States, 573 U.S. 351, 358, 2014. When Congress includes particular language in one section of a statute but omits it in another, let alone in the very next provision, this court presumes that Congress intended a different meaning. Quoting Rousselot v. U.S., 464 U.S. 1623, Accord Digital Reality Trust, Inc. v. Summers, 138 South Connecticut 77777, 2018. Second, the structure of section 1512 supports the conclusion that section 1512C2 defines an independent offense. Section 1512C2 delineates a complete crime with different elements from section 1512C1, and each subsection of section 1512C contains its own attempt prohibition, underscoring that they are independent prohibitions. The two subsections of section 1512C are connected by the conjunction or, indicating that each provides an alternative basis for criminal liability. See Loughran, 573 U.S. at 357. Ordinary use of or is almost always disjunctive. That is, the words it connects are to be given separate meanings. Internal quotation marks omitted. In Loughran, for example, the Supreme Court relied on the use of the word or to hold that adjacent and overlapping subsections of the bank fraud statute, 18 U.S.C. 1344, state distinct offenses, and that subsection 1344-2, therefore, should not be interpreted to contain an additional element specified only in subsection 1344. ID, see also Shaw v. United States, 137 SC2 462, 465, 469, 2016, recognizing that the subsections of the bank fraud statute overlap substantially, but identifying distinct circumstances covered by each. And here, as in Loughran's section 1512C's, two clauses have separate numbers, line breaks before, between, and after them, and equivalent indentation, thus placing the clauses visually on an equal footing and indicating that they have separate meanings. 573 U.S. at 359. Third, the introductory word otherwise in section 1512C2 signals that the provision covers obstructive acts that are different from those listed in section 1512C1. See Black's Law Dictionary, 1101, 6th edition, 1990. Otherwise means in a different manner, in another way, or in other words. See also, e.g., American Heritage College Dictionary online, in another way. Differently, under other circumstances, see also Gooch v. U.S., 297 U.S., 124, 128, 1936, characterizing otherwise as a broad term and holding that statutory prohibition on kidnapping for ransom or reward or otherwise is not limited by the words ransom, and that reward to kidnapping for pecuniary benefits. Colasos v. United States, 368 F 3D 190 200 2D circa 2004, construing otherwise in 28 USC 2466 1C to reach beyond the specific examples listed in prior subsections, thereby covering the myriad means that humans' ingenuity, thereby covering, quote, the myriad means that human ingenuity might devise to permit a person to avoid the jurisdiction of a court, end quote, of Begay v. U.S. 533 U.S. 137, 144, 2006, recognizing that otherwise is defined to mean, quote, in a different way or manner, end quote, and holding that the word, quote, otherwise, end quote, introducing the residual clause in the Armed Career Criminal Act, 18 U.S.C. 924 C2B2, can, but need not necessarily, quote, refer to a crime that is similar to the listed examples in some respects, but different in others, end quote. The purpose of the word otherwise in section 1512C2 is therefore to clarify that the provision covers obstructive acts other than the destruction of physical evidence with the intent to impair its integrity or availability, which is the conduct addressed in section 1512C1. The word otherwise does not signal that section 1512C2 has less breadth in covering obstructive conduct than the language of the provision implies.